Hello and a warm welcome. You're watching India Tonight with my colleague Shibani Garat and myself coming to you from the Chennai studios. Now, Shibani, it's been an awful lot of action that we've seen in Parliament of late, but the fact is that the monsoon session of Parliament has not seen a meaningful debate on bills so far, especially amid the constant disruptions. In fact, a continued blockade of debates and lack of consensus has prevented the government from tabling one of its most wanted reforms, and that's the bill to amend the Foreign Contributions Regulations Act. Now, while it's not a surprise that the opposition is against the amendments to the FCRA, which makes NGOs and organizations accountable for the foreign funds that they receive, we also have lawmakers from the US raising questions on the law that the Indian government aims to bring in. So a bit of a balancing act there, Shibani, that the government is trying to bring about. Firstly, those amendments to the bill, and also having to contend with all that it may face on the geopolitical front, especially with regard to these amendments itself.
Question also that, we're supposed to ask today, and we have a stellar panel of guests joining us. Now, the FCRA issue, Jude, is not just a political one anymore. It seems to have led to a diplomatic face-off as well. MEA has made it clear that Parliament is within its rights to legislate the law aimed to protect national security, and India's ambassador to the US has put out a fact sheet on why India needs the FCRA. Now, how it does not, how it does not in any way target any particular religion. Now, we have an esteemed panel, as I mentioned, of guests this evening to decode the FCRA bill. We have Desh, Ratan, Nigam, he's a senior lawyer, Supreme Court. We have Sanjay, Hegde, he's a senior lawyer at Supreme Court. And then we have Veena Sikri, she's a former High Commissioner of India to Bangladesh. Thank you so much, ladies and gentlemen, for joining us today on ET Now. Let's go over to you, Mr. Nigam, first. Help us understand why there is so much of conversation in Parliament, and of course, why are US lawmakers so concerned about FCRA? Help us understand, is there more than what meets the eye at this point in time?
Well, Shivani and Jude, let me bring out an instance of 24th February 2012 when an interview of Manmohan Singh was published in a magazine called Science, where he clearly said that foreign funding to Christian churches is stopping India's growth. And he gave the example of the nuclear plant that was there. And thereafter, what happened to Manmohan Singh, and the entire cabinet started disobeying him, not listening him under the instructions of some super PM. And therefore, there is a history to it. And you know how the copper plant in Tamil Nadu was also became defunct because of the NGOs who were funded from abroad, which report is also on record. However, FCRA has been there since 1976. And 2010, everything was consolidated and a new act was brought in and nobody objected to it. Why in 2026, when there are changes taking place in this particular act, the amendments, why suddenly they have started, shouting, including the senators? Whereas in their own country, they have very strict, laws about foreign funding, whether it is UK, USA, Canada, Australia. They all have, strict laws ensuring accountability, transparency, and also taking care of the national security, sovereignty, integrity. And then they have the same laws there, but they don't want India to have it. The only reason out here is the conversion is prohibited out here in this particular amendment, and also the foreign nationals are prohibited from taking key managerial or control positions unless exceptions are provided. So these are very important, these issues. And thirdly, the myths which are being created out here is that it targets a particular religion, Christian minorities or minority civil society organizations. I don't think any lawyer, or for that matter, anybody can point out a single provision in this particular act which states a particular religion. It applies to every organization across the board, irrespective of the religion. And India is a sovereign country. The legislative matters are perfectly within the domain of a parliament. They are not subjected to, pressures from abroad. And therefore, people must understand that it is our parliament which will make a law, and India is governed by rule of law, and every organization has to follow
Right,
that.
Mr. Nigam. No, thank you for those opening arguments. I think you've really set the context straight with regard to, the conditions under which the bill and the amendment is being debated. But let me get in Mr. Sanjay Hegde in on the conversation. Mr. Hegde, I think let's start with a basic question. What specific problem is this bill solving that the existing FCRA framework, like Mr. Nigam pointed out, which has been around for a while, cannot exactly solve? Like, is there evidence, for instance, that the existing law is inadequate, or are we simply making an already stringent law even more stringent, perhaps, Mr. Hegde?
Well, let me put it this way. The FCRA is a bad idea of Indira Gandhi and from the emergency times, and it is being made worse now. That's where I stand. The FCRA comes out of a siege mentality which says that there are foreign funds and foreign agencies which will put up NGOs. Mr. Nigam said that, people objected to the Vedanta copper smelter in Tuticorin. At the end of the day, it was the Indian Supreme Court which shut it down on environmental grounds. There are lots of people who donate to causes all over the world. Right now, the opposition to the FCRA is also to some extent from the church, because there have been donations to the church or to church funded properties going on right from pre-independence times. There's lots of church American money which was sent, for instance, to put up missions in Chhattisgarh over 100 years ago. The local churches have taken over. There are fights within the churches. At the end of the day, all these amendments tend to put in a regime where the government will take over. This is, to use Prime Minister Manmohan Singh's famous statement on demonetization, organized loot and legalized plunder. That is the way that the church and some of its leaders have been viewing this particular legislation. Today, the US is run by a leader who owes a lot to the fundamentalist church.
Right.
Let me tell you that, if there is one post on Truth Social, we will not be having this debate much more.
Right. Thank you so much, Mr. Hegde. Now let's go over to Veena Sikri. Ma'am, help us understand from your diplomatic lens and diplomatic standpoint, how is now this becoming a tool for a geopolitical leverage? First, there were the Section 301 investigations, and now there is this whole religious freedom and civil society. Is it being used as a diplomatic leverage to keep India in its place when it comes to trade talks around, of course, tech and defense pacts that India is already in conversation with the US?
Well, we do know that many pressure points have been built up on so many issues, and especially in recent years because of the new use of tariffs as a pressure point. But I think on the FCRA issue, and let's be very clear on this, that India is certainly not the only country in the world that is restricting or is in any way, I don't think the word restricting even is correct, because we are not restricting foreign contributions in any way. We are regulating them through a proper authority. Now, for example, I think let's be very clear that every country in the world has their own laws and regulations on this. The Americans have had a law, the FARA, since the 1930s, and they have amended it recently with FATCA some years ago. I think the UK, Australia, all these countries have found the need to upgrade these legislations on foreign contributions essentially because of national security concerns.
Right. So, sorry to interrupt you, ma'am. Help us understand then, why is in fact US, has objection to a parallel to FARA then now, at this point in time?
At this point, within the USA, as has been already mentioned by my co-panelists, the MAGA lobby, the ultra, religious lobby, the evangelists, they are in very great prominence, and they have chosen to raise this issue. But I think the points that our ambassador in the USA, Vinay Quatra, made are very valid, are very good, and very cogent. He has put it all in one place, that assets of any of the NGOs or groups receiving foreign contributions will never be affected. Even if there's a dispute, even if the FCRA permission is cancelled or FCRA registration is cancelled, even then the assets will be kept in custody. And for that, a regulatory authority has been set up. And the obligation is that they have to be kept carefully in custody and returned as soon as the issue is resolved or the FCRA registration is once again done. So this has been very carefully laid out. Earlier, there was a confusion about it. And I think the very good proof of the fact that there is no attempt to curb the FCRA or the curb foreign contributions in any way is the fact that the amount of contributions have gone up sharply, more than doubled in the last 15
Absolutely.
years, and are in the region of $2.67 billion.
Ms. Sikri, Ms. Veena Sikri, I'm glad you bring up the FARA because granted, the US does have the FARA. But my question, and maybe Mr. Nigam can take over from here, is does that justify every provision in India's FCRA bill or the FCRA amendment? For instance, which equivalent, Mr. Nigam, in any other country, and again, see, the question isn't so much about regulation, but about proportionality, right? For example, can you name the equivalent provision in any other country or any democracy where executive powers are given control to take over state assets? I mean, that almost seems like something that is uniquely provisioned in the Indian bill and the amendment. Surely, the proportionality does not justify, one might think, the intention or the intention to regulate funding and keep an eye on these anti-national elements in many ways. Does the proportionality of these amendments justify the content of the bill, Mr. Nigam?
Jude, in fact, Indian laws are made according to Indian facts and circumstances, not by the American, Australian, or UK circumstances. Now, if you look at the amendments given in 1926, if your registration of an NGO or a voluntary organization is cancelled, it is not renewed, or there is a lapse on the part of the voluntary organization, there is a provisional vesting of the state. That is the first step. If the license is not restored or the violations that you NGO or a voluntary organization commits who's receiving foreign funding does not rectify those violations or restores its license, and then it is permanently cancelled, then it is permanent vesting. This only ensures that the assets are safe, they are not frittered away or looted by certain other people. So there was a lacuna that there was no designated authority. So a designated authority has been created, which takes over these assets first provisionally and then permanently if the violations are not rectified. Secondly, there was another lacuna in the earlier act that if the assets are taken, whether provisionally or otherwise, the provision of review has been brought in, the right to be heard by the aggrieved party. If the review fails, there is a provision of appeal also provided under it. So these are redressal mechanisms, as we have in a democracy, that if you are aggrieved by the act of the designated authority or any other authority, there is a redressal provision. This is provided under all the acts. So you have a right to be heard, which is an essential part of democracy. And secondly, if you also look at for violations, earlier the punishment was 5 years. Now it has been reduced to 1 year. It has been relaxed a lot. And there is a coordinated investigation between the state and center in case of violation. So these were the lacunas which the working of the existing act threw up, and therefore these are being rectified through this amendment. So therefore, to say that this is extreme, no, you have a right to be heard. At every stage, take up any act. If there are violations, there is a redressal mechanism provided. That lacuna existed earlier, that is being rectified through this bill.
Right. At the point in time when my colleague went to you, Mr. Nigam, I saw Ma'am Sikri wanted to make a point, so I would allow her to make a point right now. And also, Ma'am Sikri, help us understand, is this friction between India and US like a temporary friction, or does this impact the relationship going forward for the long term?
No, I don't think so. It is just an issue which has come up, which many of the church authorities have raised, and we are explaining it to them. And I think that it will certainly be understood because everybody understands in the context of their own situation. And particularly for places of worship, there is a particular provision that even if a place of worship is affected and it happens to become part of the asset custody, then there is a special provision to ensure that that place of worship continues to function. There's a special provision for that. So I think there is no attempt in any way to affect the places of worship. And I must also point out that there is the issue of national security in terms of counterterrorism. When you're trying to make sure that the assets, that the finances that come in are not misused and not used for terrorist purposes and, in geographical areas which are near to a very sensitive border area. So we must also look at the broader perspective of the FCRA and not link it only to religion. Because I think the issue of religion has been very, very carefully safeguarded, because we know in India, for everybody, the religious issue is a very sensitive one and it should be provided for very carefully so that there is no misapprehension about this. And I think the government has explained this very carefully, and our ambassador in USA has also explained this very carefully. So I don't think that this issue of religion will be a sticking point, and because it's very rare. It hasn't happened in many cases. Most cases, what the problem has been that while we have had this FCRA, the reporting provisions have not been complied with by many of the NGOs functioning in India. And we must remember also that in India we have 3 million NGOs. Only 14,000 of them are registered with FCRA. So it's not as if NGO activity as such is going to be touched in any way. And if the provisions are complied with in terms of, the FCRA, you should be FCRA registered, you should comply with the requirements of informing where the money is coming from, and thirdly, report about the utilization of the funding. 3 basic provisions are there, and there's a restriction that you cannot use more than a certain percentage of the money for admin purposes and so on. So these are very normal, ordinary restrictions which are there in every country's ruling about foreign contributions and how they are received and how they are to be treated. So I don't think there is any need for getting worried about this. And I think that this is being explained carefully to all the agencies in USA and other countries who have concerns about it. So I don't think there's going to be a major problem on.
Ms. Veena Sikri, I actually buy the national security angle to this. And granted, I, for one, am always in favor of national security being prioritized over all else. But the question that we must be asking, and I'm sure multiple religious organizations are also asking, because granted, they will face the brunt of these amendments should they be brought about, and perhaps Mr. Hegde can respond to this, is why drain the swamp to catch the crocodile? For example, the cancellation clause of the amendments. Why should cancellation or non-renewal of an FCRA potentially give the state control over assets built over several years with these foreign contributions, Mr. Hegde? Isn't that a punishment that goes well beyond merely regulating the foreign money itself?
Of course it goes. Let me give you an example. I went to a school called Don Bosco, Matunga, Bombay, right? It was built by Italian fathers of a particular order. They got money. They built the thing. Thereafter, even now, maybe there are some donations which keep the educational mission going. Similarly, there is Jipmer in Pondicherry, again built by Christian missionaries. So all those assets, if these people are compulsorily required to register, and thereafter you have the district collector saying, no, I'm going to take it over, it will provisionally vest in me, you have not done X, Y, Z, and thereafter we will take it over permanently, as Mr. Desh Ratan Nigam said. What is happening is that a mechanism which is used for PMLA cases, money laundering cases, that same kind of architecture has come into this act as well. People are damned if they register and damned if they do not register. There is a great deal of history also where churches are aware that rulers take away their property, going right back to Henry VIII. So therefore, if the church, for any reason, feels that its property is going to be taken over in India, then you can bet that it will have international ramifications and it will not be restricted only to the US. Right now, the US has a Christian fundamentalist approach in some matters. So it is quite natural that some congressman, some senator has been asking questions. Mr. Nigam might also remember that there was a time when, under the religious freedom laws, or Ms. Sikri might remember, that some people were even denied visas to enter the US. Do not take an unnecessary fight at an unnecessary point of time.
Now, help us understand also some part of compliance and implementation. Of course, there was a truth and a myth, sheet, a fact sheet that was being discussed over Twitter. But Mr. Hegde, at this point in time, help us understand, my first question is, of course, will the small grassroots NGOs, face more regulatory burden because of the new amendments right now when it comes to, the regulatory burdens as compared to the larger NGOs that are there? Help us understand that aspect also.
No, the regulatory burden is the same. But the amount of bookkeeping and compliances which are required, a smaller NGO will be less able to sustain it or pay its CAs and other compliance officers than a big NGO can. Now, not every NGO today relies on foreign donations. Many of these international brands have opened India offices which are totally financed from India. That's how they keep out of the FCRA compliance route. But even then, there are so many causes for which money may technically be foreign, but it could come from all kinds of sources. If my brother were to send me, for instance, money to for an NGO where I run a library, then even I would then have to have that all the registrations so that I am FCRA compliant. And to say that at some point of time, some bureaucrat somewhere can decide to take it over or send me a provisional notice, most people are of a mind that this is too much of a burden, let's stick to Indian money. But there are people with legacy problems, like I mentioned my school, or like I mentioned JIPMER. That is a true area where there needs to be much more thinking at the government level before you try to push in some legislation which is not really discussed on Parliament, which has been drafted by some bureaucrat and passed in a hurry. The consequences will come to haunt the country.
I also think, sir, that the one aspect that we're not quite discussing as much, and again, Mr. Nigam can weigh in on this, is, again, as much as there is discourse about how several NGOs and several groups, could potentially be working against the interests of the country, especially with the Sterlite Copper, instance that Mr. Nigam, in fact, highlighted at the beginning of the debate. The fact is, a lot of these organizations, institutions, NGOs, in many ways, contribute to the very balance of powers that is more or less enshrined in the Constitution. For instance, a number of these groups have stood up for the downtrodden, marginalized, tribals through Indian history itself, and many of us already know this. So, Mr. Nigam, would you perhaps accept that the chilling effect in the amendment itself, in terms of clamping down on these voices, is a legitimate concern? For instance, if an NGO knows that its FCRA registration could put its assets and operations at risk, won't it naturally become more cautious about criticizing government policy? And in that case, doesn't the government then get a free hand to do whatever it wants to without seeing these balance of powers emerge in cases where NGOs and other organizations have actually stood up to the state and stood up for the voices of minorities and the marginalized? Could that be a chilling effect of these amendments, Mr. Nigam?
Well, in fact, what does these amendments do? Or the FCRA, which came from 1976? It only ensured accountability and transparency, and also concerns for national security, sovereignty, and integrity of the country. What this act wants the voluntary sector who's receiving foreign funding to disclose what is the purpose of doing it, and to ensure whether that work is being done on the ground, and to ensure that they have the registration. What is wrong with that? If there is some access by any bureaucrats or any organization, as it happens in any other act for that matter, you have a redressal mechanism. The NGOs which are working on the social field, educational field, it will not impact them. They'll only have to show the utilization of the fund for the purpose that they actually wrote in the form which they filled while getting the registration, and the states and union territories in which they were working. That's the simple aspect, and it should not harm India's national security at all. So these are simple factors, and they have to, and if they are receiving foreign funds, they have to show how it has been utilized, whether it has gone to the ground, and if they have restricted the administrative expenses to 20%. Earlier, they were 50%. So the fact remains the money could have been siphoned out. It could have gone to the purposes for which they had not listed in the form. So these are small steps that they have to ensure. For that, audit is to be done. How does one know whether the amount that you have received has gone for the purposes for which the foreign funding was received? Government of India also does its own social audit of the programs. The CAG also has introduced long time back social audits, whether the impact of the schemes is being actually felt on the ground. The social objective and purposes are being achieved or not. Even government goes through it. The social audit concept has been brought in. Why can't it there be in the private sector? There cannot be any chilling effect. Chilling effect will only come if you violate the rules, violate the purposes and the objectives, and siphon out funds and compromise national security, sovereignty, and integrity of the country. And there must be a chilling effect for that, because anybody who does that must be taken to task and penalized. However, if the people are genuine and there is bureaucratic access, we have a redressal mechanism in this particular act.
Right. Right. Thank you so much for joining us today on ET Now. Due to paucity of time, we will have to wrap up this discussion. But thanks again, Mr. Nigam, Mr. Sikri, Ma'am Sikri, joining us today on ET Now. Thanks again for joining us.